Hello, is anybody there?
Mr. Wright's on.
Okay. Can you hear us?
Yep.
Great.
Procedural rules of the commission specify that your arguments may address only one, relevant factual errors; two, relevant omissions from the report of facts submitted during the investigation; or three, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that the commissioners may ask questions. I'll ask you to introduce yourself as you come to the podium. Thank you.
Okay. So, first order of business is the adoption of the agenda and the consent agenda. Do I have a motion? So moved.
Second.
All right, and for our remote participation policy, I will ask the commissioners to indicate their vote both visually and verbally. So if you vote yes, please raise your hand. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders. Yes. Next order of business is the September 2024 minutes. Motion to adopt those. So moved. If you vote yes, you are in agreement with that motion. Commissioner David.
Yes.
Commissioner Sanders. Yes. Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Just a little bit out of order and it's going to throw me all day. All right. Reports are pretty minimal this time. I have no changes in personnel, which is a good thing. We have, for compliance, we have one case that was an unsuccessful conciliation and 4 active cases in conciliation, 4 cases in active conciliation. No agreements for you to approve today. For investigation, we had 46 new complaints with a total of 72 new respondents.
How many? 46.
46, yep. This is that new method of counting, so I'm giving you the total number of cases and then the total number of respondents because that's how we will count them later on for the annual report. Administrative dismissals, we had 20, including 4 dismissals for lack of jurisdiction, failure to cooperate, etc. 7 right to sue letters went out, 2 withdrawals with no benefits. And for predetermination settlements, we had 9 total, 7 through the commission's mediation program, 2 in private settlement, for a total of about $361,000 to complainants.
I'm sure you've told us this before. When you say the 46 new cases, we're not counting the A and B and C. That's just
Yeah. So the 46 new
Total
cases, 46 new cases is if it was an ABC case, that's one case.
that's one case. Yeah.
72 new respondents is us counting the A, B, and C separately, and that is
And
how.
separate respondents.
Yeah.
Right.
So that's how the EEOC counts how many cases we have. So for the purposes of our annual report, that's also how we count them.
Good.
So I'm giving you both of those numbers so that later on, if you look at our annual report, which is up now on the website, you won't be surprised that there were 600 cases when you only heard 150. You have a financial report from Michael. If you have any questions about that, he is here to answer them. And litigation, I would ask that we take an executive session. For new business, really the only thing is that the annual report has been submitted to the legislature. It is up on the website if you are interested. It's a fascinating 9 pages, although I think you all saw the draft. So if you want to read it again, it's online. Very exciting. I don't think there's anything else. We're gearing up for a budget year in the legislature and those 2 or 3 bills that we'll be putting forward, but nothing is going to move on that until probably December. So update you again. Then no meeting next month. Our next meeting will be, I think, the first Monday in December. I won't be here. Okay, just make note. Everybody else planning to be here on the second? Okay, great. I have nothing else for you all. Do you have any questions about any of it? Ed, can we be in?
Yes, so we'll be in recess until the published time of 8:45 for the first case.
Everything is well. Everything is well. A little tired.
All right, we will call the meeting of the commission to order and consider the cases before us on the adopted agenda. The first case is H 240136 A, B, and C, Kevin Osgood versus MCH Housing et al. And it is a recommendation by our investigator to find no reasonable grounds. Therefore, we will hear from the complainant. Present first. Mr. Osgood.
So before we get started, I just want to remind the parties and council who are here of the commission's confidentiality policy. Please do not use the names of any persons or entities who are not parties to the case, who are not named in the case. We have given them pseudonyms in the report, so when you're referring to them, please use those. As to H 24-0136, I received an email this morning from Mr. Osgood requesting that we table the case. He has not given me any documentation as to why we should table the case. He emailed me at 4:30 this morning, so I'm inclined to ask you to deny that request. And generally, when a complainant doesn't show and it's a no reasonable grounds case, we accept the investigator's report. Investigator Liva is here if you have any questions for her.
No. And Mr. Osgood is not here.
And Mr. Osgood is not here.
Do we need to move to?
I don't think you need to move to deny his request, but
No.
okay.
Sorry.
Yeah. Just a motion to accept the investigator's report should be enough.
So moved.
Okay.
Second.
So moved and seconded. Any discussion? Okay. Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders. Yes. So the findings are no reasonable grounds. We will send a letter to the parties and council confirming the results. Not that I think the council showed up for this either. So all set.
Next case is Sheila McAllister versus Lori Sapiel. H 240193 A through D, and the accompanying HUD case. Is for reasonable grounds in regards to sexual orientation and a recommendation for finding of no reasonable grounds against the defendant management. So given the request for finding of reasonable grounds, we will hear from the respondent first. Is that correct?
That's correct. Yes. Is there anybody here for Ms. Sapiel or multi-management group? Ms. Sapiel, I believe you're here. You are muted. We can't see you. Okay, great. Can you hear us?
Yes, I can hear you. Good morning.
Morning. All right, so you have 10 minutes.
Okay.
Would you like to save any of that time to respond to complainant's presentation?
You mean, do I need to say anything?
This is your opportunity to present your side of the case to the commissioners. I'm asking, you have 10 minutes total. I'm asking if you want to save any of that time to respond after the complainant presents.
No, I'll say what I need to say. She'll say what she needs to say. It's okay.
All right, whenever you're ready, go ahead.
Okay. I moved in here at Woodland Acres 2022 in September. And when I first moved here, I was in apartment 203. It was in the back and it was kind of dark. And I take care of the building for multi-management. I clean it. And so this apartment where I'm in right now, 212, is a 2-bedroom. It's out front. It's really nice. So I asked Suzanne from multi-management if I could move in here, and she said yes. So I've been here pretty much of the time. I think I was like 2 or 3, maybe, I don't know, 3 or 4 months. So anyways, I didn't realize Sheila lived under me. Well, I knew she was there, but I didn't know that she smoked and had people living with her all the time. I didn't know that. So it became an issue. And I had reached out to multi-management on a number of times. I contacted Susan Collins' office, USDA, I mean, a number of people to try to help me, aging and disability with Ross. And it just continued. It didn't matter what I did. There was a court date for 23 October. Suzanne sent me an email, said I didn't need to show up. They came up with an arrangement that Sheila was not to smoke in the apartment, have people living with her anymore. And she didn't keep that, so that was out. And so this continued, and the smoking was in my apartment really bad, suffocating me all the time and my animals. And I had to go see my doctor 3 times with doctor's notes, and I had to have tests done. So nothing was ever said in 23. There was never a gay pride flag put out in the lawn. There was nothing going on. I heard from a neighbor that Sheila was a lesbian when I first moved in here. I didn't care. It was not a concern of mine whatsoever. There's someone else here that is too. I don't care. It's not my concern. So anyways, May of 2024, all of a sudden she puts a gay pride flag out, and that's where everything came apart, because all the time I was trying to stop the smoking, nothing was being done. I was pleading for help and I wasn't receiving help. So in May, we had, I think it was a conference with Looper, and there was another lady, and Suzanne Multi-Management, Sheila and myself. And she said she wanted to come to an arrangement, an agreement with it. And I said, okay. So we got done the meeting and everything. And all of a sudden she wants money from me.
Ms. Sappiel,
Mhm.
I'm going to stop you right there. Any discussions about settlement are confidential.
Okay.
So we can't discuss those here. And I would also just ask you, I understand that Ms. Levasseur is here, so I'm not
Yes.
going to stop you from saying her name, but please don't use the name of other parties who are not, other people or offices who are not a party to the case.
Okay. Okay. Anyways, it came up to May 24, and I had put some posts on Facebook along with some other people about the gay pride community and God's rainbow, and they had taken and used it as their flag, and it really bothered me. There was never an issue with it at all until May of 2024, when she put the gay pride flag out. And I think, if I remember, she had relatives or friends or something sent her posts that I had put on. And I apologize for using her name on Facebook. I should have never done that. It was at the heat of the moment, just came out. I do apologize for that. And but Sheila had 3 to 5 eviction notice that were under her belt. I never even knew that in all the time, but I was trying to get the smoking people living with her stop, and it was so bad. But so she moved out May, I guess, for whatever reason, she moved out. And then all of a sudden I received a letter from the Human Rights Commission stating that she was against me for harassing her sexually, which I had never done. I had never said anything to her about her orientation. I had never said anything to her kids about the orientation. It was not my concern. My only concern was the flag. That was it. That's all it was. Anything else between her and I was just petty stuff passing by each other. And it just came to where it is today. It never had to come this far. If it would have been taken care of in the first place, all the smoking, all the people down there, if it would have been taken care of, it never would have went this far. And it shouldn't have gone this far, because it became an issue that wasn't healthy for anyone. And I just wanted it to stop. That's all I wanted it to do, was just stop. And it wasn't being stopped. So the flag was the end of it. And I don't know what else to say about the whole thing. My story's the same from the beginning until the end. I've never changed it. Everything that's happened should have never happened. My rights were being violated. If I knew about the Human Rights Commission a year ago, I would have contacted them about what I was going through. I wished I would have known, because it never would have got to this point. I mean, since Sheila moved, it's so quiet here, it's nice. I have a lady under me. She's a minister. It's wonderful. And I just don't want the hassles. I never wanted the hassles. I never wanted it to go as far as it did. I didn't care about her personal life. All I cared about what was going on, and no one cared about me, and no one was helping me. And that's the case, what was going on. So in the end, it all blew up with the flag, and it just became a mess, and it became ugly, and it shouldn't have. And I apologize for my part in it in any way, because it should never had happened with any one of us. We all should have just taken care of it and respected each other's space, but it didn't happen that way. And that's all I have to say about it. I don't know what else to say.
Thank you, Ms. Zappiel. You'll have about 4 minutes and 20 seconds when we come back to you. Any questions for Ms. Zappiel from the commissioners? Okay, seeing none.
Thank you.
Great. Is there somebody here for Ms. McAllister? Yeah, that phone number. Ms. McAllister, I think you're on the phone. If you would like to unmute yourself, you just need to push *6. Great.
Hello?
Hello.
Can you hear me?
All right. I can, yes. So you will
Okay.
have 10 minutes when we come back to you, or 10 minutes right now. Whenever you're ready, you can go ahead and start.
Oh, right, okay, yeah, most of what she talked about didn't have anything to do with the reason why we're here, but I'm used to that. The whole gay pride flag that was outside her bedroom window happened to be my bedroom window as well, and it was coming up on Gay Pride Month, so yes, I put a flag out front of my apartment, and I didn't realize it would cause trouble like it did. And there was a few times that she waited for me in my mailroom to take my trash out and whatnot, and just harassed me all the way in the building. I mean, I had to leave there. I didn't want to leave. I'd lived there forever. I'd lived there 7 years. And it was just turmoil for me to live there as well. I'm at a loss. I don't know what to do. I've moved out. I'm happy now. You know, I get along great with everybody in my building, and my gay pride flag is in my window, and I've had no issues with it. I mean, I don't know what else to say.
Okay. Pause your time, so you'll have about 8.5 minutes. Any commissioner questions for Ms. McAllister? Commissioner O'Brien.
Good morning, Ms. McAllister. As I understand it, and I didn't understand a lot in this case, but as I understand it, the flag, you were asked to remove the flag because, and correct me if I'm wrong, this was a violation, not because it was the gay pride flag, the rainbow flag, but because it wasn't, no flags were allowed. Is that true? Is that how you understand it?
Yeah, there was a lot of stuff outside, a lot of decorations that were allowed to be put up until I put my gay pride flag up. And then everything ceased. Nothing could be outside anymore.
Okay. Thank you.
Yep.
Any other questions for Ms. McAllister? Correct me if I'm wrong, we did not receive a submission of disagreement with regard to the findings.
Right,
For
so the
multi-management
reasonable
group.
grounds finding is not contested.
Okay.
Wait.
So yeah, the finding against the finding not
Oh.
again, the no reasonable grounds finding as pertains to multi-management was
Okay.
not contested, so we won't hear
Yeah.
from them. Ms. Sapple, you have 4 minutes and 20 seconds if there's anything further you'd like to add.
Okay. I listened to Sheila. I just find it awful odd that in 2023, there was nothing like that going on. It was just the regular stuff that was going on. She was still smoking, having people living with her when she was given a number of eviction notices, which never went through. And she just stated that her gay pride flag was under my bedroom window, even though I'm on the second floor. She said it was under her bedroom window too. She slept in the living room. Her bed was in my living room where my windows are. That's why I couldn't open my windows when it was nice out, because all the cigarette smoke would come up into my window. And it didn't matter it just didn't matter. You know, it's just where it is today. So it wasn't put up in 2023 because right at the end of it, in May of 2024, when she put it out, I love the Lord. I'm not going to make no bones about that. The rainbow promise and stuff. I don't go up and say anything cruel or mean to anyone about their sexual orientation. That's not how I operate. I never said anything to her. Yeah, her and I had little squabbles here and there when she lived here, but it was nothing to the point where Suzanne came here and put us both in a room and, reprimanded us or anything. It wasn't like that. If it would have just stopped, all of it would have just stopped, it never would have got to where it was. And she probably would have still been here, but it didn't work that way. That's not the way it worked out. I'm just neutral. I'm quiet. I don't want to make, I'm a quiet person, but when I'm being provoked, I stand up and defend myself. Of course I do. But this issue, when it got to the point where it did, and her and I wouldn't have been able to talk to one another because it was too heated at the moment. I just want it to go away. She's living where she is now. I'm here. It's quiet here. There's nothing going on. It stopped. I'm so grateful for that. I'm so thankful for that. And I just think we should leave one another alone and not try to get things from each other that don't belong to each other. I mean, it happened, and no, it wasn't a good scene. It wasn't for anyone. But this is, this is also something that we can use in the future for future things that happen. How can we make it better? Can we make a difference? Can we try to bring people together rather than fighting with each other on their own when management hasn't stepped up and stopped it? That's their responsibility. I rent here. It's not my house. So I can only say so much to management. And then I give it to them, and it's their responsibility to take care of it. And I do what I can do on my end. I just can't sit in an apartment and be suffocated and just not be acknowledged for anything at all. And it just keeps going on and on. It's not a good scene. It's not at all. It shouldn't happen to anyone. My story's always the same because it's the truth. It never changes. It's where it is. It's up to you guys. You guys are going to do what you're going to do. And, I trust you with that. That's all I can say. I thank you.
Commissioner David, yes.
The investigator's report focuses on the post you put on the internet. Was that before or after the flag was removed?
That was before. That was all before, because Sheila moved out in May. All of that happened within a short, maybe couple months in that period right there when everything just blew up at the end. And then to top it all off, she put the gay pride flag out because she knew it would upset me because she knew how I felt about God's rainbow. And that's why she did that, even though she may not say she did, but that's the way I looked at it. And it really upset me. And it didn't get acknowledged. And, people had a few things here, bird feeders and stuff and this and that. Suzanne didn't say anything about it because it wasn't causing any issues. But when it became an issue between Sheila and I about the flag, that's when she had to step in, and she took them out of the ground and gave them both back to us again. But those posts that were on Facebook were for everyone. I have all my posts set up public. They're not for any individual person. Anyone can read them. Anyone can see them. And I don't direct anything at anyone. The only thing, like I said, I shouldn't have done was use Sheila's name. I apologize for that. It was in the heat of the moment. I should have never said it because I never said it. And all the other times I would post something on Facebook about the smoking and doctors and stuff. That came up at the very end, and that's when all the problems began.
And it included the address as well as the name, correct?
Including the what?
Including her address, including yeah.
What do you mean?
Sheila's address, her name and address. You acknowledge that you referred to her specifically by name.
No, I just said her name. I didn't say her address. I said just my neighbor that lived under me. I never put no address there. It never even says that. I even looked at the post. There's no address there. It just says Sheila McAllister, my neighbor who lives under me. That's
your
it.
Your address there?
Say that again.
Is your address there?
Well, yes, we were at the same address. I'm over her and she was under me. Yes, but no one knew what my address was. It's not on my public information and my profile. None of that is. Not my phone number either. So no one knew where we lived. Unless your family.
Commissioner Sanders.
Good morning, Ms. Sapiel. I think I heard you just say that the only regret you have about the post is that you named the complainant. I'm curious about that. The investigator cited very specifically the last sentence of this post as violative of the law. That last sentence reads, "They are an abomination to God Almighty." And I'm curious, my impression of your presentation this morning is that not only do you believe that statement is appropriate, but that it does not violate the law. Is that your position here today?
What it says in the Bible about being homosexual, it says it's an abomination to the Lord. That's what I quoted from God's words himself in the Bible. I put that down and you can look it up yourself. It's not something I made up on my own. As far as one of my posts on there, something about two women can't have a baby, raise a baby or something. No, it's not what I meant. I didn't mean two women or two men cannot raise children. I said they can't conceive children. That's there's a difference there. If two women and two men want to raise children, that's up to them. That's their prerogative. I'm talking about as far as gender-wise. That's it. And that wasn't directed at one person. That was directed at anyone.
Ms. Sapiel, do you understand at this point that this language violates Maine law?
What language?
The language in the post that the investigator cites to.
About it being an abomination?
Correct, to the extent that you communicate that to any party, like here, that one statement can constitute a discrimination in a hostile environment in the context of a party's housing. Do you acknowledge that today?
But that's my belief. That's not something I go up and say something to anyone in the gay pride community. I don't say things like that. That's my belief. That's how I see things. When you post something on social media, anyone can read what you post. It's up to them whether they want to comment on it or not. If they don't, they can just move on. Like I come across a lot of posts on social media I don't agree with. I don't comment on it. I just keep going. That is just something I put down because it's in the Bible. So if it's not a contradiction because it's God's words, it's not saying anything, walking up to someone and saying, well, this and that. I don't operate like that. I've never said anything to Sheila or anyone else about their sexual orientation. I don't walk up and say anything. I don't do anything like that. That's not even appropriate. Those are my beliefs. And Sheila and I never even spoke about it. Her and I have never had a face-to-face conversation. She said to me when I first moved here in 22, well, she said it in the meeting with Looper, that she told me in a community room downstairs that she was a lesbian. She did not. That would have been in the very beginning, early 23. I heard it from another neighbor. And there's someone else here that's gay. I don't care. I'm friends with that person too. It's not my choice or my decision who they are, what they do. That's just my personal feelings.
Any other commissioner questions for Ms. Sapiel? Seeing none, we'll go back to Ms. McAllister. You have 8 minutes and 37 seconds if there's anything else you'd like to add. And again, if great.
Hello?
Yep, we can hear you.
Okay, so what do you need?
Just, you have some time left. If there's anything else you'd like to say, you don't have to. If you feel like you've said everything you want to say, that's fine. But if you'd like to say anything else, you have about 8.5 minutes left. Ms. McAllister?
Back then that I didn't believe in God and I was a lesbian. And she had a problem with me ever since that day. I mean, we had a big blowout in the community room, day room, whatever you call it, in front of everybody in the building. I just, like I said, I'm at a loss for words. I don't know. I don't know. If you guys have questions, I'll answer them, but
Any commissioner questions for Ms. McAllister? Commissioner Douglas?
Yes. Ms. McAllister, good morning.
morning.
I'm just, I've been reading this report here and it's focused on the social media post. And the allegation is that post sort of created a hostile housing environment. And I think it'd be helpful if you could talk to us about how the post affected your living situation.
Well, I didn't dare to leave my apartment. When I did leave, I left the grounds altogether. I didn't dare to go outside and be with my neighbors. I just because she wandered all around because she worked for the landlord. I mean, which is fine and all. She did a good job. The main common areas were clean, but I hated to go out in the hallway because I just didn't want to run into her and have something said to me. And I shouldn't have to live in fear in prison.
Okay, thank you.
Any other, yeah, Commissioner O'Brien?
Thank you. I'd like to, if you can expand on that a little bit. Commissioner Douglas just asked, how did the post, how did that cause a hostile living environment? And and you were afraid to go out, but it appears to me, date-wise, it was just hostile anyway. I mean, not specifically because of that post. I just.
No,
Go ahead.
a lot of the neighbors liked the flag, and of course there was only one person that really didn't, which is fine. It's fine. I didn't like the Christian stuff she put up on a bulletin board all the time, but I didn't touch it. I read it or I didn't read it, and I went on with my life. And it's just, I didn't get the same respect in return. I never made a post against her because of her stupid little sayings on the bulletin board every week. Like she said, I can scroll past them. I can wheel my wheelchair right past those posts, But to call me out on something social like that, it made it so like the neighbors, I felt, were picking sides, and they shouldn't have had to.
Yeah, go ahead.
Okay. But again, I go back to the hostile housing environment, and you said you were afraid to go out. You were afraid, uncomfortable and afraid to go even in your hallway. And
yeah, and
when
when I left, I made sure I left the premises altogether.
Okay.
I didn't hang around.
Okay. But the flag was put in May of 24, and you filed May 23rd. So are you, if I was complained, are you saying, and I'm just trying to get this clear, are you saying that in those 2 weeks, that's when it began, that you were afraid and felt really uncomfortable? Was it the 2 weeks, or had it been going?
No,
Because the post,
I felt like
wait, hold on a minute.
Hold on, Ms. McAllister, let Commissioner O'Brien finish.
Yeah, because I'll lose it. Because the post, as I understand it, is what is causing you to, that's what caused you to feel uncomfortable and scared. Am I correct in that? Those 2 weeks?
Yes, it was hostile before that, yes, but after that post, I didn't feel comfortable even in my own home.
Okay.
I'm not a paranoid person, but I just was paranoid after that.
Okay, thank you.
I'm sorry, just one more question. Do I understand correctly from your testimony that the neighbors had access to this post? You were aware that neighbors could see it?
Yes, they commented on it. A few of them did, and then they took them off.
All right, thank you.
Any other commissioner questions for Ms. McAllister? Seeing none, thank you both. And next we'll hear from Nooper Leva, the investigator assigned to this case.
Good morning, commissioners. I don't have anything to add that wasn't in the report, but I'm happy to answer any questions if anybody has one for me.
Commissioner Douglas.
Yes, good morning, good morning. Sort of following up on Commissioner Bryant's questions, and I think where she's going with that, you know, the report really seems to hinge on this one social media post, right? And I just, you know, obviously we're talking about one post and then the creation of a hostile housing environment. It would be helpful, I think, if you could just expand a little bit more on how it is you came to find a hostile housing environment based on this one specific instance.
Sure. So when I read this quote, it immediately to me sparked something inside of me that made me fear for myself if I were a part of this community. And I think that objective standard is enough to satisfy the law here. Whether or not the environment was already hostile didn't play a really big role into my decision in this case. It still felt like this alone, even if nothing else had occurred, this alone would have created a hostile enough environment because of the language and because of how it specifically identifies a protected class of people that Ms. McAllister fell into. I felt like that was sufficient here. Did that answer the question?
I think you did. Thank you.
Mm-hmm.
Commissioner Davis.
Good morning, Cooper. Respondent worked for management?
Yes. Yes.
What was the relationship?
It appeared that she just did work around the grounds, cleaning things. It wasn't like there was any sort of deeper relationship in that respect.
Is she compensated for it?
That was not a question that I asked. That wasn't relevant to the housing inquiry that I was making.
I guess that's my question, and maybe it's a legal question. Does there have to be some connection for it to be a housing discrimination complaint, other than being a tenant?
Not from my understanding. From my understanding, anybody can interfere with your housing rights, a neighbor, the landlord. It doesn't have to be like where you live, the person who owns it or runs it doesn't have to be the one discriminating.
A question for Barbara.
Yeah, maybe a question for Barbara.
Any other commissioner questions for Nooper?
No.
Thank you, Nooper. We've heard from the parties and the investigator. At this time, we are looking for a motion unless you have questions for Commission Counsel that you'd like to ask first. Commissioner O'Brien.
Yeah, I definitely do. I have to say, I kept reading this over, trying to find the punchline. I'm sorry, but isn't there, and I wanted to ask you, Barbara, as the non-attorney in this, is there, according to the human rights statute, if someone has an opinion, okay, someone has an opinion, the respondent is saying that she has no problem with the gay community, but her opinion as a Christian, as she said, is that the flag has been co-opted. I'm having a really hard time with with what constitutes an opinion, and is it because, and a belief system, well, no, that was opinion, but if she had not put it online, is that the crux of this?
I mean, putting it online was certainly part of the problem. I mean, the Post says they, being the gay community, are an abomination to God Almighty. That's not an opinion about the flag. That's an opinion about the community. It's directed at, it includes Ms. McAllister's name. I mean, the standard for a hostile environment is severe or pervasive conduct, and Newper found that this was severe, objectively and subjectively hostile, and because of protected class. And the question is, does it meet that standard? And for Newper's recommendation is that it does. No one's saying that having an opinion is illegal. You can have whatever opinion you want. When you direct it at a person and publish it, it's different. That's not just having an opinion.
Okay, and is that what you just said? Is that somehow, is that in the Maine Human Rights Act? The fact that it's published, that it's, I mean, I'm really struggling with this.
Is that specifically in the Human Rights Act? Of course not.
Well,
But the Human Rights Act does make it unlawful to create a hostile environment. Again, so then you have to just look at those factors and
Okay.
decide if it's enough for you.
okay,
I wonder too, you know, I think the struggle that Commissioner O'Brien is articulating is, you know, there's an intersection here potentially between what the respondents' rights are
Right.
to have sincerely held religious beliefs and sort of how does she express those? So certainly she's got rights to those beliefs and opinions. And then the complainant's rights as she, you know, sits in a protected class to be free from discrimination in the context of her housing. So those two things are at an intersection point here. And so that's what I think sort of the crux of the struggle is.
Mhm.
Where do respondents' rights stop, right, and begin to interfere with complainants' rights?
Before we get too far into discussion, I think we should have a motion if there are no more questions for Commission Counsel or investigator.
Well, I do have a question, Barbara. The behavior, it's not essential that she be a tenant for this to be discriminatory behavior, right? That Ms. McAllister be a tenant, she could be a neighbor and still attack her and
I mean, yes, and it's not, the recommendation is not written as interference, but that's obviously how we get there. Yeah, anybody who interferes with the right to be in a housing environment free from discrimination. So we've had this it's usually a tenant because it's usually apartment complexes like this. But what matters is the interaction between the individuals and whether or not that makes the complainant's housing environment hostile. I realize I'm saying the same words over and over again, but that's because that's what the test is.
So if I not being a tenant and not in the housing, attack a tenant in housing specifically, I can violate the statute by making that housing hostile to that person.
We have had that case precisely, in
Okay.
fact, and it just wrapped up in court. So yes.
Okay, but if I do that same unlawful behavior, unlawful against the tenant, if I do it to a neighbor, it's not unlawful. I think that's the struggle, is that the same behavior with a post online specifically naming the person can be unlawful if it's against the tenant. but not unlawful if it's,
It would also be unlawful against the neighbor. If somebody,
would it be unlawful? Yeah, I mean,
let's say you made the post about this person,
right,
you'd still be making her housing unsafe if you were pointing out, if you were attacking based on a protected class.
see, my tendency is to say, no, the remedy there would be libel and slander of the neighbor, but not discrimination, discrimination.
But it happened because, if you find that it happened because of membership in a protected class, then it's discrimination under the Maine Human Rights Act.
Okay, all right, that's it. Thank you.
I got there.
Ready for a motion?
Or do we still not have one?
Yeah, I'll move that we adopt the recommended findings of the investigator that one, there are reasonable grounds to believe that respondent discriminated against Ms. McAllister on the basis of sexual orientation or gender identity. And two, that there are no reasonable grounds to believe the respondent multi-management group discriminated against Ms. McAllister on the basis of sexual orientation or gender identity. That complaint should be dismissed.
Second.
So moved and seconded, any discussion?
Yeah, I mean, I think that the commentary before we got to this point, particularly the commentary by Commission Counsel, is just directly on point here. You know, Ms. Sapiel has a right to her Christian views, you know, this sort of intersection between her right to her views and what constitutes discriminatory conduct. You know, what she doesn't have a right to do is to interfere with somebody's right to enjoy their living situation. And this post, you know, I know this is what the report focuses on, but this post has some really concerning language in it. You know, it's an abomination to God. I'm not going to stand for it. They took the flag and putrefied it. They are abomination to God Almighty. I mean, if you are a member of a protected class, as I am, and you read a message like this about you, which identifies you specifically, that's a problem. And I do think that can create a hostile housing environment. So I think there's an even chance that Ms. McAllister will prevail. Does Ms. Sapiel have some defenses to make? Does she have some arguments to make at trial? Of course she does, but I think that this meets our even chance standard, and so that'll be my vote.
I agree with Commissioner Douglas. I'm troubled by the respondents' seemingly inability here today to recognize, notwithstanding very clear legal analysis, that she in fact violated the complainant's rights. And if that's the case, which, you know, based upon the circumstances here today, my worry is that this matter may not be instructive to Ms. Sapiel, and if that's true, there's likelihood of this reoccurring again. So that's what I'm concerned about. My hope is that our discussion here today, and certainly to the extent that Ms. Sapiel participated in this process, that she can come to understand how her conduct and speech violated the complainant's rights. That's my hope.
Any other discussion?
Yeah, I'm gonna vote in favor of the finding. I mean, I've come to that sitting here and with the interaction with counsel, that it's an attack on a protected class. And I think it meets the standard of at least an even chance at trial, and that is the standard. There's also a chance at trial that you could get a jury getting wound up with free speech and all of that kind of stuff. But that's an even chance is an even chance. And I agree that the post is horrendous. It's specific. It's public. It's identifying. Those are the things that put it over the line for me.
Commissioner Walker.
I will support this motion, and I think Commissioner David's analysis is exactly like mine. I think it is a close, factual case, and that lends itself to going to a trial and decide those points. Our investigator, and I accept her explanation that it was helpful, found that it was objective enough to create a hostile environment. It's fine to have that tested in court.
Any further discussion?
I just can't get there. I'm sorry. If I were if I had to make the vote to switch it the other side, I mean, I wouldn't do it. I understand I'm in the minority, so I feel more comfortable. But I really have, I've read this case many times and tried to do it. So
I just want to be clear, you don't have to apologize for that.
No,
It's your opinion. That's why you're here.
Okay, well, thank you.
Ready for a vote?
Yes.
All right, so the motion is to find reasonable grounds as to respondent Ms. Sapiel and no reasonable grounds as to respondent multi-management group. If you are in agreement with that motion, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien.
No.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
So the findings are reasonable grounds as to Ms. Sapiel and no reasonable grounds as to multi-management group. The commission will send a letter to the parties and the council confirming the results of the hearing. Before we move on to the next case, I just wanted to, I think I saw Attorney Hoffman, although I do not see her now, so never mind. She was here for responding to the case.
In the first case. Oh,
So I was just going to let her know that we found no reasonable grounds, but I don't see her here anymore, so we
Probably figured it out on the agenda. But
so the last case for hearing this morning is H 240209 A and B, Delmar Head Jr. Versus Westbrook and Wright Properties. Oh, no, I'm sorry, versus Wright Properties. The complainants are from Westbrook. So the recommended finding by our investigator is for a finding of no reasonable grounds to believe that discrimination occurred and therefore we hear from complainants.
Attorney Maybe, you have 10 minutes. Would you like to reserve any of the time?
I'll reserve 3 minutes up front, but so I apologize off the bat. I lost my voice last week, so I may cough a little bit. Not contagious anymore. You don't need to squeeze your ears back or anything. But good morning. Thank you for being here and hearing this case. And thank you to Investigator Brindley for completing the investigation. I appreciate the report, although we too object with its conclusions. So I want to start off with why this case matters. Delmar Head Sr. is an individual who's been diagnosed with multiple disabilities that affect his mobility and cognition. As a result, he can't live independently and he relies heavily on his family for support. And so that's really why it's so important that he live in a unit that's accessible. Earlier this year, through no fault of their own, the Head family needed to move out of their previous apartment. They began looking for new apartments. Delmar Head Jr. found the apartment in question, went to look at it, signed the lease. He was not with his father at the time. The very next day they came to look at it. It became immediately apparent that Delmar Head Sr. could not live in this apartment. It just did not meet his needs. And as the individual with the disability, he's in the best position to make that determination. And so they immediately notified respondent of this issue and asked to be let out of the lease and to return their rent. Unfortunately, he didn't grant that request. And so as a result, the money wasn't returned and my clients weren't able to find a new apartment because they didn't have the money upfront to pay. And ultimately, as a result, they experienced months of homelessness, living out of motels while they searched for a new apartment. And so what the law says about this case and why we disagree, as was made clear in Investigator Brindley's report, a complainant must establish 6 factors to make a prima facie showing of discrimination based on a reasonable accommodation request. At that point, the burden shifts to the respondent. They can then make a showing that the proposed accommodation was unreasonable. In this case, based on the fact that it might be an undue financial burden. And so Investigator Brindley reached a conclusion on that second point that it was unreasonable, which necessitates that they also found that we had made our prima facie case. So it's really just that second point that we're disagreeing with, that it was an undue financial burden. And so turning to that report, the final paragraph is a statement, respondent provided that it would have caused an undue financial burden to return the rent payment because respondent had already taken the premises off the market and could not find a new tenant to rent the premises for 2 months afterwards. And that's the entirety of the finding as it relates to that point. And so, and I don't think the record establishes anything further than that to support a finding of undue financial burden. I do, however, think that the record supports the opposite conclusion. And I start with a letter that was written by respondent's initial attorney, David Van Bars, in response to our second accommodation request, a formal written accommodation request. And in that letter, Attorney Van Bars stated that the apartment was taken off the market when the lease was executed, and despite having been put back on the market once Dell, son, indicated he was not going to take possession, my client has been unable to rent the apartment to a new party. And so if we go back to the report and we look at the timeline established in that report, it's clear that the lease was signed, and then the very next day, my clients responded. So at most, based on their statements, the unit was off the market for 1 day. We're not talking about a month off the market or even weeks. We're talking about a single day off the market as justification for why this is in fact an undue financial burden. And so if we look at sort of what an undue financial burden looks like to courts, the closest we can get is looking at that in the context of employment. It's not exactly analogous, but it does give us a window into the court's reasoning when deciding what is and what isn't an undue financial burden. And courts have held that, in the employment context, employees must show that the accommodation is reasonable in the sense both of efficaciousness and proportional to costs. Even if a prima facie case is made, the employer has the opportunity to prove that upon more careful consideration, the costs are excessive in relation either to the benefit of the accommodation or to the employer's financial survival or health. And I think that's really important because we're not talking about, is it convenient to the individual? Is it convenient to the employer, or in this case, the landlord? We're talking about an actual undue financial burden that needs to be shown as having an impact on their finances, a significant impact. And so, turning back to this case, in their initial response to our complaint, respondent disclosed that Wright Properties LLC owns more than 36 units across the state. And so this was one of 36 units. It was being rented for $2,700 a month. So I think that paints a picture of Wright Properties overall, and I think you need to take that into account when talking about undue financial burden. It's not just about this one unit, it's about the business being run. And again, one unit for $2,700, but one of 36. And so I think that, again, while I appreciate Investigator Brindley's report and their efforts, the simple statement that, that the premises was off the market during this time as being sufficient justification for proving undue financial burden, I don't think that's met here. And, in my opinion, the only undue financial burden that was suffered was by my clients, by not getting that money back, by not having the opportunity to rent a new apartment. They were homeless for 2 months. They were living out of an apartment. They're paying that off with credit cards. So they're in, financial debt as a result. And so, taking that all into consideration, I just urge you to not adopt the investigator's findings and to instead, issue a finding that discrimination did occur when respondent failed to reasonably accommodate my client's request. That's all I have. I'm happy to take questions. I'll reserve the rest of the time.
Attorney, maybe could they have kept the security deposit?
So ultimately, the security deposit was returned to my client, wasn't returned until after my clients had become homeless, but they do have that money back. Could they have, I mean, the part of the accommodation request was to return the security deposit. So I think, it's the same question.
Accommodation request for what? Their mistake?
Well, so I wouldn't say it's their mistake. So the son rented the apartment, it was trying to find a new apartment.
Right, pay the money.
Pay the money and then
Sign the lease.
sign the lease. And then it's the next day that the father shows up. And again, that's when he discovers he can't live there. He wasn't, they're coming from a different place. It had been years since they moved. So, it's not, the son was optimistic and he was hoping this place would work and he needed a place, but ultimately the father's in the best position to understand his needs. And that's when it was determined that it wasn't safe for him to be here. We have a letter of support from a doctor.
No question about it. He can't live there.
Yeah.
Okay. Thank you.
Commissioner Sanders.
Just curious, with respect to the payments that complainant made when he signed the lease, it's not specific in the report, but I'm curious, was that first month, last month, and security deposit?
I believe it's just first month and security deposit. So $2,700 for rent and then I believe it's another $2,700 for security.
Okay.
And yes, the security was returned, but again, after they become homeless.
Okay, so that's a total of $5,400.
Yes.
And the respondent elected to return half of that money, correct?
Eventually,
Okay.
yes.
Why isn't that a sufficient reasonable accommodation? It seems like, right, respondent's position could be, to Commissioner O'Brien's, excuse me.
I'm not gonna ask.
Commissioner David's comment, right? Your client signed the lease, right, made a mistake, didn't appreciate apparently at that time that his father would have difficulty, right, traversing the stairs. Why isn't it then sufficient in a demonstration of good faith for the respondent to have returned half, right, of perhaps arguably what they didn't have to return because there was a contract in place?
I mean, I think that if there was no disability involved, that makes sense to me, right? Like showing good faith, I understand this isn't going to work out for you, so I'll return half of it. But what we're talking about is a reasonable accommodation based on a disability. And so I don't think that just being reasonable is the standard. It's about, did my client make out their prima facie case? Do they have a disability? Do they have this need? And then only if it's an undue financial burden does respondent not get to return. They don't get to negotiate, right? They don't get to say, well, this seems fair to me, or I'm running a business here, I don't want to have to deal with this. The law says they have to deal with this because my client has a disability. And so I think I agree with you. That sounds reasonable, but not when we get into the fact that it's based on a disability and that the request was for everything. And so either you're denying it and you're saying, this doesn't work for me because it's an undue financial burden, or you should grant it all.
Okay, thank you. Curious too about, you're analogizing undue burden in the housing space. By looking at employment cases as well. So a couple of questions there. First, in the employment context, one of the things that a court will look to is, of course, what's the relative burden on the employer, but in this case, right, analogizing to the entity that owns the unit. I'm curious about trying to assess that relative burden. We're talking about a dispute of $2,700. So I'm trying to get a sense of how burdensome that might be. Do you know, was it in the record, for example, facts like what kind of annual revenue the respondent has, and just trying to contextualize what this $2,700 means for them?
Absolutely.
Only if it was in the record.
Yeah, no, I don't believe it was in the record, and someone else can correct me if I'm wrong. I'm not aware that it is in the record, but I think that's an important point, which is I don't believe the record was developed enough to come to the conclusion that it was an undue financial burden. And so I'm not standing here saying I'm positive that it wasn't. I just think the record should have been developed such that it would be easier to make that determination. I'm basing that on the fact that it's only one line, right? Like this case hinges on that it is an undue financial burden, but the report sort of, not hand wavers it, but it's a one-line statement saying, yes, it was met, but I don't think the record supports that.
Okay,
Yeah,
all right.
and so I can't answer your question, but I think that
Okay.
illustrates my point.
No, that's helpful. I'll ask
Yeah.
the investigator.
Investigator Brindley is saying that it's not in the record.
Not in the record, okay. Barbara, a question for council. I'm gonna tap you in. Can you comment on complainant's counsel borrowing the undue burden assessment from the employment space and applying it in the housing space?
I mean, there is an undue burden test here too. It's just, I understand why there's not a lot of housing cases. So I think that's why Attorney Maybe is referring to employment cases as an example.
Okay, that's helpful. Thank you. And then one last question.
Do you want me to otherwise comment on?
If you have thoughts, want to opine.
I just want to be aware that there are other commissioners who also have
Yes.
questions.
One last question. I know Commissioner Douglas is thinking a lot of things about certainly monopolizing the time.
So I would like to get his.
Can we stay on
task?
with your indulgence though, one more question. So you really narrow in on the sort of the factual posture, right? So your client signs the lease on March 1st. He makes a request to be let out of the lease on March 2nd. And so I think I heard you say that at most, right, that apartment should have been off the market for one day. Curious though, so that doesn't strike me as a fair assessment because, right, the management company would have had to put the unit back on the market, and reasonably couldn't we infer, right, that there would be some kind of a delay before the next tenant would be able to move in? I'm just curious about that timing.
I mean, the reason I sort of focus on the timing is because that comes directly from the original Attorney David and Mars that, despite having been put back on the market once Dale indicated. So to me, that's saying the day he told them it's put back on the market. And yeah, there may have been a delay.
To the next month.
But I think that's true, even if my clients hadn't signed a lease, right? They looked at it and it didn't work out. There may have been a delay to the next tenant anyway. And so it's about the delay that my client would have caused. And my point is that it's maybe not insignificant, but it's very, very minor, right? Because we're talking about my clients looking at the apartment. They wouldn't have taken the apartment off the list before they had looked at it, before they had committed to signing, right? So it was still on that day until they sign the lease. At some point, they do take it off, right? Maybe later that day or that night even. And then the next day, my clients come back. And so we're talking about hours at most. And it may have taken a little more time for them to get in. But also, they, in the record it established that it did take them 2 months, I think, ultimately. But they're trying to attribute that to my client's actions, which I don't think are reasonable. I don't think that explains the 2-month gap.
Yes.
Okay.
Okay, and with that, I'll turn it over to my colleague to my left.
Oh, I thought you had some questions.
I don't have any questions right now.
Who signs the lease?
So the son, Delmar, had Junior and his cousin.
And does he tell them that he tells them that the father is gonna live there? Does he tell them the father has disability?
No, and I don't, not initially, and I don't think
Isn't that essential to finding discriminatory intent?
Yeah, he eventually does tell him, right? So initially when he goes to look at the apartment, he doesn't disclose a disability. And you don't need to, and I don't believe you need to disclose a disability until it becomes relevant, right? So if you're moving into an apartment, you don't need to disclose all of your disabilities because they may never become relevant. It's only once they become relevant that you have an obligation, or not an obligation, that's when you can choose to disclose that and make the reasonable accommodation request. So for instance, in a different context, my clients could have moved in and 6 months later, something could have occurred that they needed a reasonable accommodation. And the fact that they didn't disclose that disability up front is not a barrier for granting the RA.
Right, and that would be a completely different case if if they were then requesting a reasonable accommodation after they've been living there for 6 months.
Well, I guess my point is the fact that they didn't disclose initially isn't, I don't believe it's a barrier to fighting discrimination, because it's only when the father comes that his disability is a barrier that they need to disclose or that they choose to.
But the landlord doesn't require the father to sign the lease. They sign a lease and pay the money with the son, who doesn't disclose the disability. In other words, I mean, I tend to agree sort of instinctively that if it's a big management company, that the amount of money is not a substantial financial burden. I'm hung up on the fact that where is there any discriminatory animus? I mean, it seems as though they've said, all right, we'll meet you halfway. I'm sorry, the mistake, here's your security deposit, but you something we're gonna keep a month's rent.
Yeah, I mean, I just to that point, I think the fact that, on day 2, right? So if they had, it's only a day later, but again, on day 1, when they sign the lease, the disability is not an issue in that they haven't determined Del Mar Senior. Again, he's in the best position to determine, right, as the individual with disabilities.
Is it a different case if it's not 1 day, it's 1 week? And then is it a different case if it's 1 month before the father shows up? He's in California and then he comes to.
I think. I'm sorry, I didn't.
And I can't live here.
Of course, I mean, I think every case changes with the facts, right? And so it is a fact specific, but I do think when we're talking about undue burden, right? The facts that if it had been a month, right? And then to go back and say, well, I want my money back, then I think it does lend itself to the fact that it may have been more of an undue burden, right? Because he's basically asking for all of that rent back when they lived there. My clients never moved in. It had been a day. And so I do think the timing matters, particularly for my clients, because it was such a short period of time. The disability, he could not live there. And they were simply asking for their money back so they could find a place that worked for them.
Thank you.
Commissioner Bryan. Thank you. Real basic questions, because that's how I get to, yeah. Before you get to the undue burden, could you, and I can't find it exactly in here, but my understanding was the understanding of the respondents was that the father never signed the lease.
Mm-hmm.
He was a guest. So so that's where I'm hung up. What was and again, this may be a legal question for Barbara, but that I'm hung up on the fact that the son was the one signing and a public accommodation request after the fact was made on behalf of the father as a guest is do you speak to that?
Yeah, I would love to. So he's not a named tenant in the lease, but he's not a guest. He is very much a tenant. He's, under Maine law, you don't have to have a lease, right? And so there are tenants that will, and so it's not that there's necessarily a requirement that everyone be named on the lease, but he's certainly not a guest. He was always intended to live there full time. He would have the right to be evicted if there was an eviction, right? They couldn't go around the FAD process if they wanted him to leave. So he was always going to be a tenant. He just wasn't named in the lease, in part because of his disabilities. His son had power of attorney over him, so he signs a lot of his documents. And so I think
if they understand it, it was not full power of attorney.
Not full power of attorney, but I guess I mentioned that to say that to the son, it made sense that he would go and deal with the sort of negotiations and lease and then bring his father the next day because, that's sort of the relationship they have and the responsibilities he has. Sorry, I didn't know if there was a question there. Okay, but yeah, no, I just want to make clear, there was no expectation that the father would be a guest. He was always going to be a tenant. He would be living there full time. Yeah, absolutely.
I do have one more question. As I said, I'm not focused on the undue financial burden. How do you say that he meets the second requirement that respondent knew or reasonably should have known of complainant's disability?
Because he disclosed it in the request. The next day he said, he called and said, my father.
The next day. Doesn't he have to disclose it before he signs a lease?
No, you disclose at the time you make the reasonable accommodation request. And this goes back to my example. If 6 months in something comes up, you disclose at that day, 6 months in, I now have a disability, or now I'm being affected in this way. And so I'm disclosing my disability or my need based on a disability at the day that it becomes an issue.
Do you think we'd have a case at all if the son had said, oh, by the way, he's got a disability and he's got to look at the stairs and see if he's going to be able to handle it, we'll be here tomorrow? And the landlord had said, fine, we'll talk about it tomorrow, but we'll take the money today. That would be a different case, wouldn't it? That would be a crucial factual.
I don't think it is crucial, because I think the moment the RA request is made, that's starting the clock, and that's when the disability needs to be disclosed. I think it would be inappropriate to require him to disclose that need before he wants to or needs to make that request. That would be asking him to disclose all of his disabilities on day one on the off chance that later on it becomes an issue. And so I think he discloses on day two, and that's when it becomes an issue. And he shouldn't be required to disclose any sooner than that.
Curious about, one of the things that's not lining up for me is, as you know, the son is aware of his father's disabilities, of course, is functioning as POA for medical purposes for his father as well. I'm just really curious, presumably, right, the stairs were open and obvious when the complainant went to look at the apartment. So if it's in the record, why wasn't it immediately clear to your client that that his father would have difficulty navigating stairs, and which would make that unit unsuitable for his father?
Yeah, I mean, absolutely. So they had the location they had been living in before, they'd been living in for a number of years.
Okay.
And so, the son, while very intimately involved in his care, I think isn't an expert in all of the functional limitations that his father experienced, particularly as they progress, right? So they had been living in a previous unit and things were going well. They needed to find a new place. I think the son understood that stairs were a challenge, but I don't think he appreciated how big of a challenge they had become. And it's only once the father comes there, after not having to navigate this before, that it's, and again, immediately apparent to all involved that he can't do it. It's just not safe for him to be there. And so again, yes, the son has some insight, but he can't make that ultimate determination. And he wasn't, I don't think, aware that it had progressed to this point where it felt as unsafe as it did for his dad.
Okay.
And it's only seeing it and experiencing it that becomes clear.
Questions for Attorney Baby? None. You'll have about 3 minutes and 10 seconds when we come back to you. My understanding is that respondent was represented during this process, but I don't see counsel on the Zoom meeting unless Mr. Johnson, is that you?
Yes, I'm covering for Attorney Pattershall today on behalf of the respondents, Wright Properties and Matthew Wright.
Great. Yes, you have. Sorry, I'm just catching up because I wasn't aware that you were covering for Attorney Pattershall. That generally somebody emails me to let me know that, so.
I apologize.
That's all right, Samuel Johnson. Okay, so you have 10 minutes whenever do you want to reserve any of your time?
I could reserve 2 minutes, please.
Okay, whenever you're ready, go ahead.
Well, good morning and thank you, everyone. I guess from a factual standpoint, there's been discussion relative to the undue burden and the first of the month. There was negotiations exchanged between the claimants and the respondents prior to that March 1st date, in which it was communicated there are other interested renters for this property. Ultimately, and we're referring to the father and the son, the father is the only complainant with a disability, and the son went to view the property on his behalf, knowing the disabilities of his father. He viewed the properties, he signed the lease. The father did not sign the lease. And then it was communicated after the fact, when the father did go eventually to view the property, that they did not believe it was going to be feasible for them to live there. I guess the starting point that's very important in the analysis is noted in footnote 1 of Investigator Brindley's report. It was asked about earlier, there was a representation that the son has the power of attorney for the father. I guess that's important for two reasons. First off, if you are acting as the power of attorney and in your father's best interest, before you commit to a 1-year rental, it's prudent to do what needs to be done to determine whether he can live there or not. Obviously, based on the investigation, there was only a medical power of attorney found. Another crucial piece from that footnote is the lease of record was only signed by the son on his own behalf. There was no signature on behalf of the father, and the father's name is not included anywhere in the lease. And so the father was a guest, but not a tenant at the time. I think another important fact in that footnote is the father never, as an individual with a disability, never made a reasonable accommodation request and therefore could not have been denied one. So the only individual complainant with a disability was not a tenant of the property, did not sign the lease, did not make a reasonable accommodation request. The son, who is not disabled, signed a 1-year lease to live at a property, presumably have his father with him as a guest at that property, but knowing his father's limitations. And, I think based on those facts alone, you don't need to get to the reasonable accommodation request. I think if you do take that step to the reasonable accommodation request, there's another hurdle in that a reasonable accommodation request is one to use and enjoy the housing. And I think that is important language. It's a request made to use and enjoy the housing. Where here, the request is made by the non-disabled son to get out of a 1-year lease, not to use or enjoy the housing at issue, but to get out of his contractual obligations that he undertook to pay for the housing for a year. But I do think if we do get to the reasonable accommodation request analysis, that Investigator Brindley was correct in finding an undue burden. And I go back to my point about there were other interested tenants that did not rent the property on the first. The first of the month has been referenced, and then the following day being the date in which it was requested to void or rescind the contract. But in the housing market, the first of the month is an important date because that's when most rentals typically start. And so it's not necessarily accurate to state the property was off the market for only a few hours or a day at most, where you had other tenants who would have undertaken a rental on the first and then stayed true to their obligations for the full year. And again, it's not disputed that the property was in fact taken off the market when the lease was signed by the son, and that it took 2 months to rent the property. And so the retention of only a portion of the first month, or retention of the first month's rent with return of the security deposit is not unreasonable, and is certainly representative of the undue financial burden, where there's a full other month after the fact where there is a loss there, and there's a loss relative to what was contracted for, in that if there is an early termination, the tenant's son agreed to pay 2 months rent on top of the prior month, and that wasn't enforced. He allowed them to basically back out of the contract, recognizing that it's going to cost a significant amount of money and time on the part of Matthew Wright and Wright Properties to try and get the property listed again and re-rented. So from respondents' perspective, respectfully, based on the findings of Investigator Brindley in footnote 1, the reasonable accommodation request is not even need to be analyzed, as the individual with the disability not only didn't make a reasonable accommodation request, he wasn't a legal tenant of the property. And secondly, the reasonable accommodation request here is not, we need something to use and enjoy this property. It is, I don't want to live here as I contracted for anymore, because my father, who you didn't know about and who you didn't know was disabled, now has informed me that he can't live here. And I think, thirdly, if we do get to the reasonable accommodation request, there is sufficient evidence and facts developed, namely that the property wasn't able to be rented for 2 months, to suggest that it was an undue financial burden for return of not only the security deposit, which was done, but the first month's rent. And I guess just lastly, kind of thinking this through and taking it to, I guess, a logical extreme, if you open the door for non-legal tenant guests to essentially, if you have a tenant who wants to be out of a lease and they decide to have a guest come stay with them who may or may not have a disability, and there is an accommodation request made to rescind the lease based on that disability. If that's extended to non-tenant guests, as essentially the argument is here, I think it creates an unfortunate precedent that's not contemplated by the reasonable accommodation statute. And so I'd be happy to take any questions that the commission might have.
More questions for Attorney Johnson? Commissioner David.
Yeah, Attorney Johnson, what the argument that you just made about that would expand, that would allow anybody to have a guest come, and if that guest is disabled, then be the excuse for getting out of a lease, 3 months into it. That's what you said. But the facts of this case are that the complainant did inform the agent or whoever's showing him the property that it was for his uncle and his father, right?
I believe it was communicated that the uncle and the son were signing the lease, but the lease does indicate that there would be 4 occupants of the property.
And the lease indicates that.
So the lease, well, it's unclear whether the lease indicates that. There's some language that says 1, there's some language that says 4. I guess for purposes of this case, the communication was not specific to, I have someone who is going to be disabled living with me, and the stairs or other features of this property might become problematic in the future. Again, I think the question asked earlier was, if that's communicated and then there's a time period given for the property to be viewed, or had the son brought the father with him at the time prior to signing the lease and paying the deposit and first month's rent, it's a situation where we're either not here at all because the property wasn't rented, or it's a significantly different factual scenario where there is communication of a disability and potential issues with that disability before there's a contractual obligation to pay and reside at the property.
But footnote 4 of the report says that the complainant is not disabled, but is an aggrieved person, which is a term of art in the statute, because of his association with the father. He's a caregiver for the father. Do you agree that he's an aggrieved person?
I understand the finding of an aggrieved person because of the care for his father. Again, this is a request made after a contract is signed without any communication or knowledge provided to Mr. Wright or Wright Properties about a potential disabled person. And again, I think it goes back to the initial negotiation, viewing of the property, all of which the son is in the best position to know this information, to ask questions or to take steps to make sure that if the property is not going to be fit for his father, that this is determined before there's a contract obligating him to live there for a year and to pay that rent and to pay 2 months rent if it's canceled early, which was not enforced here.
Thank you.
Thank you.
Any other commissioner questions for Attorney Johnson? Seeing none, you'll have 3 minutes and 18 seconds when we come back to you. Attorney Mate, you have 3 minutes and 10 seconds.
Thank you. Just very quickly, a couple points. Attorney Johnson mentioned that he believes the father was a guest. I don't believe that's the case. He was always an intended tenant. He made reference to the fact that the lease is a little confusing, but it does reference 4 people living there. Again, my client, senior, relies on his family. There's no way in which he could not be living full-time with his son and his other family members. He needs that care. And so the intention always was to move from a unit in which they are all living together to move to a new unit in which they are all living together. He was not a guest. He was not staying there sometimes. He was staying there all the time, and he needed the rest of his family to be living with him as co-tenants. And then just also this reference to use and enjoying the housing. I understand that the term is use and enjoy, But it's not unheard of to make a reasonable accommodation request to break a lease. This is not the first time this has ever come up. It is an understood avenue when making a reasonable accommodation request that you can request to be let out of a lease, even though technically that's not using and enjoying the unit. It still falls within this framework. And so I just want to mention those 2 points, and I'll take any more questions.
Any other commissioner questions for Attorney Page? None, thank you very much. Attorney Johnson, you have 3 minutes and 18 seconds if there is anything else you'd like to add.
Just very briefly, and then happy to take any questions. I think just going back to the initial exchange about when the property was viewed and the lease was signed, as I mentioned earlier, there was text message correspondence that Investigator Brindley had where there was a discussion about other potential renters being available, and also in which the son was communicating they were still under lease at their other property. So I guess it's not clear whether they decided to break that lease early or not, but at least based on the text messages that were in the record, there is housing available even after that March 1st date, once they were able to rescind the lease with the payment of the 1 month rent. And so I guess with that, I would be happy to take any additional questions. Otherwise, we would request that the finding of no reasonable grounds for discrimination against either complainant be adopted and that the complaint be dismissed.
Commissioner, questions for Attorney Johnson? Seeing none, thank you, Attorney Johnson. Next, we will hear from Lex Brindley, the investigator assigned to this case.
Good morning, Commissioners, Council, Kit, Executive Director. I made a few notes while I was listening, and I'm just going to run through them, hopefully in the chronological order that the case arose. So in this case, the complainant did sign this lease. He did not sign on behalf of his father, but there were text messages, as previously indicated, wherein he told the landlord that his father was intending on residing with him. I believe there was some comment about tenants needing to disclose their disabilities when they sign a lease. That is not true. Complainant, knowing that his father had a disability, requested a reasonable accommodation on his father's behalf because no other reasonable accommodation would allow them to use and enjoy the premises. Therefore, in early March, when father saw the apartment, saw that he was not able to access the unit, complainant on his behalf requested to be let out of the lease, which the respondent granted. The issue then arises to the money that was involved. It wasn't until later in the month when the complainant asked for all of his funds back as a reasonable accommodation, which I determined not to be reasonable, and also that it caused an undue burden. Simply put, the respondent did grant the reasonable accommodation to be let out of the lease, but to request for the entirety of the funds when the respondent had already provided the security deposit didn't seem like a reasonable request for father's disability. I'm open to any questions.
Lex, any questions, Commissioner David?
Alex, what is the evidence that it's an undue financial burden? I mean, there's a difference, isn't there, between a single an owner owning a single piece of property and a management company that is renting tens of units.
Certainly, and I understand that. However, I mean, Attorney maybe mentioned it previously when respondent's initial attorney, Attorney Van Bars, they sent in a letter late March after the request for the money had been made by the complainants. He stated the apartment was taken off the market when the lease was executed in early March. Despite having been put back on the market, no one was able to take possession of it. And it wasn't just that it was an undue burden on the respondent that they had not been able to release the unit for 2 months. It was the fact that the request for the entirety of the money, the security deposit and the 1 month's rent, was an unreasonable request.
But the request for the security deposit was not unreasonable in your judgment? Why do you make that judgment?
Well, the request was to be let out of the lease, which was granted.
Right.
They later requested for the return of all of their funds, the security deposit and the 1 month lease. The respondent determined to give the complainant back the security deposit, but to retain the 1 month's.
You could argue that they own 1 day's rent, 1/30th of the $2,700.
They had signed a lease for a whole year.
Yeah. And you do agree, and you put in your report that son is an aggrieved person, correct?
Correct.
Okay, thank you.
Any further commissioner questions for the investigator?
Oh, I'm sorry. So I think you said that there is no evidence about the financial burden. What $2,700 means to that landlord.
I did not ask any further questions regarding respondent's finances, no.
Right, okay. Thank you.
Any other commissioner questions for the investigator? Seeing none, thank you, Lex. At this time, we've heard from the parties and the investigator. We're looking for a motion. There are 2 proposed findings.
I'm sorry. I'll do it. I move that to adopt the investigator's recommendations as written in the report. Number 1, there are no reasonable grounds to believe that Wright Properties LLC and Matthew Wright discriminated against Delmar Head Jr. on the basis of disability. 2, there are no reasonable grounds to believe that Wright Properties LLC and Matthew Wright discriminated against Delmar Head III on the basis of disability. And 3, the complaint should be dismissed in accordance with 5 MRS section 4612 sub 2.
Second.
And moved and seconded. Any discussion? Commissioner David.
Yeah, I'm having a day in which I'm making a lot of decisions here that I didn't expect to, because I do read these and have a fairly good idea of where I think I'm going, but I'm going to vote against it. If it is the case that the son is an aggrieved person and everybody agrees that that's the law, and the lease indicates that the disabled person is going to be a tenant, that's not the same as the argument that somebody could come along a month later and move in a disabled person and then try to get out of their lease. And if it's the case that there's no evidence that it's a financial burden, then it leaves me with the investigator trying to settle this case, saying, well, that's a reasonable split, but that's not what we're doing. I think if he's disabled and they make that known immediately, and if it is correct, again, a legal statement that didn't seem to be challenged, that you don't, oh no, Alex said it herself, you don't have to disclose the disability at any particular point before requesting the accommodation, then I think it's a reasonable accommodation. So that's the explanation for my vote.
Any further discussion? Seeing none, the motion is to find no reasonable grounds on both recommended findings. If you're in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
No.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds on both recommended findings. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing. We will, let's see, I need a motion to go into executive session. Commissioner O'Brien, seconded Commissioner Walker. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. start the video. That little, do you have the little remote for the camera?
Right here.
That little circle should let you.
There you go.
Yay. Okay. So I need a motion to approve the settlement in H210257 A and C, Carey versus CB Matson et al.
So moved.
Second.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Great. And I need a motion to litigate H240052 A and B, Garcia versus Chapman and Nicola Antonio.
So moved.
Second.
Commissioner David? Commissioner Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. That's it. Thank you, everybody. We will see you in December.
Okay.